14058 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right. So last time we were here, the parties appeared and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right. So, Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were.
Buckle up, guys. Today we are diving into one of the wildest courtroom encounters you'll ever see. Right from the start, the stage is set. Sovereign citizens going head-to-head with the law, armed with bizarre arguments and misplaced confidence. The case centers around Arnold Chavez, who believes he's cracked the code of the financial system. What follows is a battle of logic versus fantasy that will leave you shaking your head in disbelief.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks, and it's more of a accuracy of the actual accounting that I'm trying to make sure, and, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owed $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
That's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender.
All right, guys, here's where it starts unraveling. The judge asks about critical documents, and it turns out Chavez's side failed to deliver the required interrogatories. The attorney admits the mistake, and Chavez claims he never even received them. What should have been a straightforward defense is already falling apart. You can feel the judge's patience thinning as Chavez struggles to hold his ground on the most basic procedural step.
Personal security, which I'm entitled to rights to.
No, I'm not buying that. No. Listen to me. Listen.
It's not about. I have it. I'm going by the law, Your Honor. I'm not just making up anything.
No, you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card, you used the credit card, you have a balance on the card, and you didn't pay on the card. They don't owe you anything.
So so when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right, Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was gonna file one, but this hearing was a little bit too early. The motion would have had to been filed the next day. So I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. Where did I? 1 second here. I have them.
No, wait a minute. December 19th, here's the problem.
Okay. It's gonna have to be January 9th.
Okay,
My clerk's indicating. So.
I will get that
motion
out
for
right
summary
away. I had it
disposition.
prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
Now this is where things take a bizarre turn. Chavez boldly claims he isn't the debtor at all. Instead, he insists he's actually the lender, and the bank owes him. The judge quickly shuts this down, pointing out the obvious: Chavez has no evidence, and his logic is upside down. This is the core of the sovereign citizen playbook, trying to flip reality on its head, but in court, fantasy collapses fast under pressure.
Camera on your microphone, please, sir. All right, we're back on 24010674, the Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of. I talked to them in the chat. They confirmed it, and I have they gave me a bill credit for the inconvenience, so that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through.
Here's the moment the judge makes it crystal clear: this case is already headed for the end. By scheduling a summary disposition hearing, the judge is essentially saying Chavez's defense won't survive. Chavez barely realizes the hammer is coming down, but the writing is on the wall. This is the turning point where the courtroom drama shifts from argument to inevitable defeat, and the clock is officially ticking on his doomed strategy.
Okay, all right, here's what we're going to do. I'm setting a date. So what do we need discovery on this? What, Mr. Gothal, so this is a credit card bill.
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands.
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
Switching gears to a second case, Chavez finds himself facing Discover Bank. His excuse this time? An internet outage supposedly kept him from attending the last hearing. He demands due process, but the judge calmly asks if he even has a defense. Once again, Chavez dances around responsibility while the court presses for a straight answer. It's déjà vu, different case, same unraveling playbook, and another judge unimpressed by the
Motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
and a judgment in the amount of what is claimed in the complaint, $4,378.29 will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set.
This is the breaking point. The judge lays it out clearly. Chavez has no valid defense, admits the debt, and can't provide any evidence. Without hesitation, the court grants summary disposition, awarding the bank thousands. The entire case ends in one sharp ruling. This is the harsh reality sovereign citizens refuse to accept. Courts run on facts and law, not ideology. The judge doesn't waste time, and Chavez's battle ends right there.
All right, we're all set. Thank
I
you,
don't have
Mr.
no words.
Mr. Arnold, I have ruled against you.
I
I
have
am allowed to
evidence.
do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Now we hit the meltdown moment. Another defendant, Sherman Moore, refuses to even acknowledge his own name. He insists he's one of the people and not the legal entity in question. The judge and prosecutor push for clarity, but Moore spirals deeper into identity games. It's part comedy, part tragedy. The courtroom stuck in circles as Moore clings to pseudo-legal jargon. This is sovereign citizen logic at its most absurd and most revealing.
Or you can come forward, sir. Yeah. Oh. Okay. Are you Sherman Moore?
I am not.
You're not, okay. And so are you appearing on Mr. Moore's behalf?
Yes,
Okay,
I am, yes, here for that matter to handle the matter that's at hand.
okay. And are you an attorney, sir?
I am the attorney, in fact, for the said name at hand here.
Okay, so you are an attorney representing Sherman Moore?
Yes, I will be handling the case for Mr. Moore.
Okay. And are you licensed by the state of Washington to practice as an attorney?
I am not licensed or a bar member or a lawyer or anything of the such, but I am here as a beneficiary executor for.
And here's the finale. The judge rules that Moore failed to appear and finds all infractions committed. Case closed. But even after losing, Moore refuses to accept reality, declaring he's just the man of the Moore family and rambling about appeals. It's the perfect ending to a string of courtroom delusions. And that wraps up today's video. If you enjoyed this breakdown, don't forget to like the video, subscribe to the channel, and we'll see you in the next one.